watching this now will be deeply worried about the future of our country and will not be impressed by this spectacle. A number of the points of order that we have heard have articulated a series of finely detailed points, but they amount to the same thing, a tedious repetition. Is there anything in the rules of the House that prevent the abuse of the time made available to this House by making the same point over and over again?
Well, I don't think it's helpful when people just make the same point over and over and over again. It has to be said that, as I myself have often observed, it's not unprecedented, and the point has just been made elegantly and eloquently from a sedentary position by the honourable gentleman member for Brent North. Continued repetition is not entirely a novel phenomenon in the House of Commons. So I'll deal with it, but I do say to the House, there is a 10-minute rule motion with which to deal, and the honourable gentleman, the member for Aldershot, is waiting to present that 10-minute rule motion, and we do then have important business to dispatch. And unless people really feel they've got something new by way of a point of order that has to be raised, I would ask them in all courtesy to consider not doing so at this time. Point of order, Andrew Percy.
Speaker, can I ask you firstly to confirm that members have an absolute right to raise points of order with you and to challenge you in what I think is an excellent job you do as a servant of the House. This afternoon we have been told we're reprehensible by some members, accused of wasting time, and similarly accused of being part of a coordination. I'm part of no coordination in this place and never will be. Secondly, my second point, Mr. Speaker, is with the greatest of respect to you and the decision you made, and I am agnostic on the decision you have made. Agnostic decision you have made and believe you have the absolute right to make it. But what I would just say, Mr. Speaker, is that when we talk about the public, out there are a lot of people who believe there is a conspiracy and a stitch-up, a procedural stitch-up taking place by a House of Commons that on the substantive issue of leaving or remaining in the European Union is grossly out of touch with the referendum result. And with that in mind, whilst accepting your decision and indeed being more than happy to support you in that, could I ask just again that perhaps any advice that has been proffered on this should also be put in the public domain so the public can make their own decision about that?
Has just said advice to me is private. But what I would say to the honourable gentleman is twofold. First of all, perhaps I can concur with him. I know the honourable gentleman, and I know that his whole political background and track record in this place prove that he is not part of coordinated efforts. He is very much his own person, and he knows that I've always respected him for that, as well as for a number of other of his qualities. Secondly, when the honourable gentleman refers to a perception out there, let me just again, and it to some degree comes back on earlier points of order, say this, and let me say it explicitly. It's not for the chair. I often have to say this to constituents and to people I meet around the country. Either to try to push a policy through or to prevent a policy being pushed through. That's not the role of the Speaker of the House. The role of the Speaker of the House is to chair as effectively as he or she can in the chamber, in the management of today business, including in the selection of amendments and new clauses and so on. What the House chooses to do is a matter for the House. And if that applies across the piece, manifestly it applies to the subject of Brexit. What happens on this subject is not a matter for me. I am simply seeking to facilitate the House in deciding what it wants to decide. That has always been my attitude, and it remains my attitude, and it will continue to be my attitude. Let the House decide on the policy. And point of order, Yasmin Qureshi.
Thank you, Mr. Speaker. Mr. Speaker, I wasn't intending to make a point of order, but I think it's important that we place on record, certainly for myself, that in the 8.5 years I've been in this place, that every time I have an occasion to speak to any of the House officials, whether it's the table office, whether it's the clerks, whether the public bill office or the private bill office, I have been given the most brilliant advice from everyone. I think it's really improper for members here to be saying that advice given to you by the clerks in the execution of their duty should be revealed publicly. I think that's most inappropriate, and it is putting the clerks in an invidious political position.
Well, the Honourable Lady, what she said, my understanding is that it has not previously been. I don't know whether there is any precedent for such advice having been issued, but it had not previously been, and I said what I did in response to an earlier point of order on the basis, once more, of clerkly advice. I know that the clerk would concur with that view, as I do. And point of order, Mr. Crispin-Blunt.
Thank you, Mr. Speaker. This year will be 30 years since we first met in the final for the competition to be selected for Bristol South, and both of us have been on something of a journey since then. And when you were elected, Mr. Speaker, you said you would serve 9 years. You have, there has been the controversy of the recommendations of the Dame Laura Cox inquiry into the House of Commons. You have been defended by, particularly by two right honourable members on the other side, about the importance of you being sustained in this position beyond the 9 years in order to oversee the discussions and the denouement of the Brexit issue. The uncomfortable conclusion, Mr. Speaker, given the points made by my right honourable friend for Chingford and for honourable friend for Somerset North East, and the implications about the precedent you have set with this ruling today, is that for many of us we will now have an unshakable conviction that the referee of our affairs, not least that you gave your opinion and your vote on the issue of Brexit publicly, that we will have an unshakable conviction that the referee is no longer neutral. And, Mr. Speaker, I just invite you to reflect on the conclusion that many of us inevitably will have come to.
Very grateful to the Honourable Gentleman for his point of view. He's quite right. We met, I think, in the ante-room of the Bristol Conservative Association headquarters at 5 Westfield Park, Redland, Bristol, in July 1989. So we've known each other a long time, and I take in a perfectly good spirit what the Honourable Gentleman has said. I think I have explained in response to previous points of order and adduced evidence in support of my argument, including that proffered by the Honourable Gentleman, the member for Christchurch, that I have always done my conscientious best to champion the rights of members wishing to push their particular point of view on a range of issues, and perhaps most strikingly on this issue. That is what the record shows. I have always been scrupulously fair to Brexiteers and Remainers alike, as I have always been to people of different opinions on a miscellany of other issues. That has been the case, it is the case, it will continue to be the case. And as far as the other point the Honourable Gentleman made is concerned, the Honourable Gentleman will know that I was re-elected unanimously by this House on, I think, the 13th of June 2017 for the Parliament, and if I have a statement on that matter to make, I would of course make it to the House first, and I think that most people would accept that that is entirely reasonable. Point of order, Jess Phillips.
Thank you, Mr. Speaker. I never thought that I was going to be one of the people who would care about the procedures of this House. I scoffed at people who talked in procedure, and when I arrived here I realised that actually it is the procedures of this House, protecting them and developing them, that actually will make our democracy considerably better. I wonder if you agree with me, Mr. Speaker, and I've seen two occasions of that this week, of what I'm about to say, is that people only care about the procedures and protecting and conserving the procedures when they don't like the outcome of the thing that is about to happen, and never when it is going in their favour.
The Honourable Lady has made her own point with force and style. I think we all know, let me put it like this, I won't get into that, but I think we all know from our own constituencies that people are inclined to complain about a process when they don't like a result. In this case, to be fair, the result will come only when we have votes on an amendment and a motion. But if what the Honourable Lady is implying is that people are complaining because they don't like the amendment that has been selected, well, you know, she's made her own point, and that may very well be so. I certainly wouldn't impugn for one moment the integrity of members of this House who have challenged me today, which they're absolutely entitled to do, and made their own points. I hope throughout these exchanges to date it will be demonstrably obvious to everybody that no matter what point people have made and how forcefully they have made it, I have heard it, and I have heard it fully, and I have heard it with courtesy, and I have responded to it with courtesy. That has been my approach, and it will always be. Point of order, Charlie Elphicke.
Mr. Speaker, can I also join with the many others who've said I appreciate and respect the extent to which you listen to everyone and ensure that everyone is given a courteous and fair and proper hearing, and that the voices and votes of all people should be listened to, including, of course, the 17.4 million people who voted leave and who will be watching these proceedings and worried about the direction of the House of Commons. On the substantive question on this amendment, can I ask for your advice and guidance on the amendment itself, in the name of my right honourable friend for Beaconsfield? And the reason I raise this is I'm wondering why you selected it, as it seems to me to be defective. It says a Minister of the Crown shall table within 3 sitting days a motion under Section 13. But it seems to me there's no ability to, no sanction if a Minister of the Crown doesn't raise such a motion, nor indeed does it say which Minister of the Crown it needs to be. And if it were to be tabled within 3 sitting days, there's nothing to force it to actually be taken, because it could end up on the remaining orders and notices section indefinitely. So why are we having this sort of amendment when it doesn't actually have, it seems to me, any effect?
I say to, and again I thank the Honourable Gentleman for what he said at the start of his remarks and for his usual courtesy. What I would say to the Honourable Gentleman on the substance of the issue is as follows. The judgment for the Chair is whether an amendment, in this context we're talking about an amendment, is orderly and selectable. It is not incumbent upon the Chair to seek to interpret the amendment. That's not my responsibility. And what I would say to the Honourable Gentleman, if he is quizzical on that point, he believes it to be, as he put it, I think, ineffective, or he said it is not effective, his inquiry on that matter should, if I may say so, be lobbed gently or otherwise in the direction of his right honourable and learned friend, the member for Beaconsfield, whose amendment it is. That, and I'm very clear intellectually on this point, that is not a matter for me. It may well be very important to the Honourable Gentleman and perhaps to other people, but it is a matter to raise either personally with the Right Honourable and Learned Gentleman, the member for Beaconsfield, or indirectly. I will take remaining points of order on these benches. Point of order, Adam Holloway.
Speaker, to the member for Reigate's point, we've all noticed in recent months a sticker in your car making derogatory comments about Brexit. No, this is a serious point about partiality. Have you driven that car with the sticker there?
Order. And, I think the record will show, and I have the highest regard and affection for the Honourable Gentleman, that I've listened to all the points of order. The only reason why I interrupt him at this point, and I hope you'll forgive me doing so, is that there was a factual error in his opening remarks. I'm sure it was an inadvertent error, and I mean that most sincerely, but it was a factual error. The Honourable Gentleman said that in recent months it had been noticed that there was a sticker in my car. That sticker on the subject of Brexit happens to be affixed to or in the windscreen of my wife's car. Yes. And I'm sure the honourable gentleman wouldn't suggest for one moment that a wife is somehow the property or chattel of her husband. She is entitled to her views. That sticker is not mine, and that's the end of it. Point of order, Mr. Nicholas Brown.
I think the House is now ready to move on. We've got a long day ahead of us, and I beg to move next business.
Well, it isn't a motion that I can accept, but I would like to propose that we come now to the 10-minute rule motion. Mr. Leo Doherty.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. I beg to move that leave be given to bring a bill to require Her Majesty's Government to derogate from the European Convention on Human Rights in its application to the conduct of members of the armed forces participating in combat operations overseas and for connected purposes. Mr. Speaker, I seek this bill to ensure that our armed forces are protected from legal pursuit and that the resolve and capability of our armed forces to deliver hard-fighting power
Point of order, Mr. Speaker.
when needed.
Point of order, Mr. Speaker.
Oh, yes. 10-minute rule motion, no.
I just wish people would be quiet.
I do beg the honourable order. We will start again. The honourable gentleman. The honourable gentleman is a person of unfailing courtesy in this House, and I think he also knows our procedures. There isn't a point of order during a 10-minute rule motion, but he's absolutely right that the speech to the 10-minute rule motion should be heard, I hope, with courtesy and respect, and I thank him for helping the chair. 10-minute, yes, start again. Let's stop the clock and start again. 10-minute rule motion, Mr. Leo Doherty.
Speaker. I beg to move, Mr. Speaker, that leave be given to bring a bill to require Her Majesty's Government to derogate from the European Convention on Human Rights in its application to the conduct of members of the armed forces participating in combat operations overseas and for connected purposes. And I seek this bill, Mr. Speaker, to ensure that our armed forces are protected from legal pursuit and that the resolve and capability of our armed forces to deliver hard-fighting power when needed around the world is undiminished. Mr. Speaker, the legal pursuit of our soldiers and veterans is a particularly painful chapter in our country's recent history and must be urgently resolved. And I relate, Mr. Speaker, as illustration, a conversation I had last year in my constituency in the Aldershot Garrison with a senior soldier who had just left the army after 3 decades of service, distinguished service, in the most elite units in the most brutal and demanding theatres of operation. Mr. Speaker, his experience of sustained legal pursuit in relation to operations in Afghanistan had left him with a deep sense of betrayal. And even though he was the son of a soldier and had himself served for 30 years, he told me that my sons will not serve, which pained me, Mr. Speaker, because, of course, soldiers do not wish to be above the law. They just want to be under the correct law. And it has been the case for generations that the law of armed conflict and the Geneva Conventions have governed warfare in the modern age carried out by our soldiers. And this was the case up until 1998 and the unintended consequences of the Human Rights Act and the European Convention on Human Rights, which has led, Mr. Speaker, to a catalogue of injustice involving hundreds of soldiers from all operational theatres. And, Mr. Speaker, these cases go on today. No other country has such a perverse situation in which soldiers who have done their duty and done no wrong face this kind of sustained legal pursuit. And indeed 10 countries, Mr. Speaker, including France and Spain, have in effect opted out of certain aspects of the European Convention on Human Rights. So there can indeed be a way forward, and we must do the same. And I would commend at this point my honourable friend from the member for Tunbridge and Morling for his terrific work on bringing this issue to the fore and getting the attention it deserves since his election to this place in 2015. And his excellent report, his policy exchange report, which he co-authored, Clearing the Fog of Law, makes clear the alarming manner in which the British military is today entangled in human rights law, to the extent that the European Convention of Human Rights applies wherever and whenever a British soldier employs force, meaning that foreign nationals, including enemy combatants, can sue the United Kingdom for breach of the European Convention of Human Rights, both in courts here in London and in Strasbourg, following military operations. So, to prevent this, we must, as other countries have done, derogate from the European Convention of Human Rights. Mr. Speaker, I would also pay tribute to my honourable friend, my honourable gallant friend, the member for Plymouth Moor View, who has tackled headlong the outrageous scandal of the Iraq Historical Allegations team and has been, since coming into this place, instrumental, along with other members of the Defence Committee, in urging our honourable friend, the Right Honourable Member for Sevenoaks, to close down IHAP, quite rightly. Mr. Speaker, the Defence Committee, led by our honourable friend, the member for New Forest East, continues to investigate the scandal of legal pursuit. And we have heard recently from witnesses that the army is running scared of the law. And of course, Mr. Speaker, this is something that must end. And it must end not only because of legacy cases and the past, it must end because of our concern for the viability of future operations. Indeed, getting the legal basis of military operations right underpins the central mission of our national defence at this time, which is the rejuvenation of our armed forces to meet a complex new range of manifold threats. Mr. Speaker, it is also part of the process of moving our armed forces from the era of counterinsurgency towards a more conventional posture, which we have lost by necessity through our long engagement in Iraq and Afghanistan. Mr. Speaker, we must state with confidence that we need conventional fighting power. It is not a luxury. Some commentators suggest that the era of military intervention overseas is over, and whatever the judgment of honourable and right honourable members in this House about the wisdom of various past entanglements, the clear lesson of history is that whether we like it or not, we will need in the future to deploy our soldiers abroad to fight on our behalf. And it will be to fight, Mr. Speaker. We need to be honest with ourselves about that. Soldiers are extremely versatile and adaptable. They can be superb peacekeepers, first-class aid workers, very accomplished policemen and effective diplomats. They can do all of these roles very well, but they are first and foremost, above all else, Mr. Speaker, soldiers whose task is to deliver hard fighting power to kill and destroy our enemies. And they must be able to do that, Mr. Speaker, in the correct basis of law, in situations where domestic human rights law is completely and utterly inapplicable. So, Mr. Speaker, to conclude, we must bring an end to the entanglement of our armed forces in human rights law. We should do this because it is the right thing to do. And we should also do this, Mr. Speaker, because we have promised to do it. It's on page 41 of our manifesto. And we should do it, Mr. Speaker, because we need to be honest with our constituents and our society about the role of our armed forces and the fact that they need to fight on our behalf. Our armed forces need to know they can deploy and fight on our behalf while adhering to the Geneva Conventions and the law of armed conflict. They need to know they can deploy and fight on our behalf and will not then face spurious legal accusations years and decades after the event. And our armed forces need to know, Mr. Speaker, that they can deploy and fight on our behalf with the full confidence of our government and our society, allowing them to serve in good faith and with pride for the safety of our people and for the defence of our nation.
Order. The question is that the honourable gentleman have leave to bring in the bill. As many as have that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Mr. Speaker, Sir Nicholas Soames, Sir Henry Bellingham, Dr. Julian Lewis, Johnny Mercer, Tom Tugendhat, Mark Francois, Sir Mike Penning, Richard Benyon, James Heapy, Jim Shannon, Gavin Robertson, and myself, sir.
Yeah.
Armed Forces Derogation from European Convention on Human Rights Bill.
Second reading what day?
Friday, 8th of March, sir.
Friday the 8th of March. Thank you. Order. We come now to the motion on the business of the House, Section 13(1)(b) of the European Union Withdrawal Act 2018, number 2. Minister or Whip to move formally?
I beg to move.
Thank you. The question is as on the order paper. I call the right honourable and learned gentleman, the member for Beaconsfield, to move his amendment formally. The question is that Amendment A be made. As many as other opinions say aye. Aye. Of the contrary, no. No. Division! Clear the lobby! Is an Amendment A be made? As many as other opinions say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Alison McGovern and Guido Bebb. Tellers for the noes, Amanda Milling and Rebecca Harris. Order. Order.
The ayes to the right, 308. The noes to the left, 297.
Thank you. The ayes to the right, 308. The noes to the left, 297. So the ayes have it. The ayes have it. Unlock.
So the main motion as amended.
The will of the House.
Order. The question is the main motion as amended. As many as are that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Order. The clerk will now proceed to read the orders of the day.
Section 13(1)(b) of the European Union Withdrawal Act 2018. You need to obey. Mr. Speaker. You're right. Shut
it. In case people didn't hear, the whip on duty said, as he should, now. I call the Secretary of State for exiting the European Union. Secretary of State, Mr. Stephen Barclay.
Mr. Speaker, before Christmas, the government presented to Parliament a comprehensive deal for the UK's withdrawal from the EU. We continue to believe that this is the best deal to honour the referendum result and deliver the certainty for our businesses, our citizens and our security. It was clear that there was much that members agreed with, but we listened to the views of the House, which in particular expressed concerns in relation to the backstop. We therefore paused the debate to enable those concerns to be discussed with the EU leaders. And, well, you're right.
I thank the Secretary of State for giving way. An intervening month from when the meaningful vote was delayed until debate restarting just now, not very much has changed. And on Monday I asked the Secretary of State whether or not he had brought forward any Plan B contingency work, and he ignored that question. I wonder, in the light of the motion that is, and the amendment that's just passed, it's rather more contingent on the government to have a Plan B, and rather urgently. Can he explain to us now what work has been going on?
Well, I think, Mr. Speaker, we have a very good early illustration in this debate of the attitude of the SNP, because even before we've got into the statement setting out what measures have been taken since the pause in that debate, they've already decided that they've reached their conclusion as to what their judgment on those measures are. So let me enlighten, he's already had one go, let me enlighten him on some of the developments that have happened since the pause in the debate. Today we have published, Mr. Speaker, a document entitled The UK Government Commitments to Northern Ireland and its Integral Place in the United Kingdom, which sets out the domestic reassurances we can provide. As the Prime Minister has said, these are one aspect of our strategy to reassure the House. Another aspect, I'll take interventions in a moment, and then another aspect will be our commitment in the next phase of negotiations to working in a more targeted and closer way with Parliament, and I will return to that later. I also want to reassure colleagues that whatever the outcome of this debate, we will respond rapidly, recognising that we must provide Parliament with as much security as possible. I give way to the member for Birkenhead.
To the Secretary of State. Secretary of State, on the order paper today, there's an Amendment 9, which deals with the question what further information the government might put before the House on ensuring that, should we need to use the backstop, this House could actually decide to leave alone without Europe deciding with us. I had a quick word with the attorney, because it involves him, this amendment, saying that he should report to the House that should the government say they've got new arrangements whereby sovereignty resides in this House about whether we should leave the backstop, he will report to the House. Might the Government therefore accept this amendment, please?
The right honourable member raises an important point, which is what will the role of this House be in the event that the backstop will need to be triggered. Obviously, as he well knows, there are safeguards which will mitigate against the need for a backstop. It is in neither side's interest to have the backstop, not least because it breaks the four freedoms which the EU have always rigorously sought. But there are safeguards, and I will come on in my speech to some of the safeguards that apply. I'll happily give way a further time given his seniority, but there are safeguards that I will come on to. Give way one further time.
I'm grateful for giving way. He says that he was listening to the debate, which is why he paused it and came back with answers on the backstop. But if he did listen to the debate, he would have known that concerns relating to importing, concerns relating to manufacturing and security were mentioned as many times, if not more, than the backstop. What reassurances and changes has he delivered on those things?
Well, he's absolutely right that there are concerns in terms of issues such as security. That is the very essence of why we need the deal in order to give the confidence on issues such as security and also to secure the implementation period where measures such as security would remain in place. But if I can come on, Mr. Speaker, to the fact that it was very clear in the debate that we had before Christmas that there were many views in the House as to what trade deal we should enter into with the EU. I'll come on to it in a moment, but just to make a little progress. The sort of trade deals including no deal. We had no deal plus, we've got Norway, we've got Norway plus, we've got Canada, we've got Canada plus, we've got Norway for now, we've got Norway forever. There's a whole spectrum of deals that different members cling to, but the reality is whatever deal needs to be put in place requires a winding down of our 45-year relationship with the European Union, and therefore whatever deal is put in place requires a withdrawal agreement, and that withdrawal agreement indeed requires a backstop. I'll happily give way.
Thank the Secretary of State for giving way. And in terms of his comments with relation to working more closely with Parliament, can I just ask him to reflect on the fact that this place is grossly out of touch with the public in terms of the fundamental issue of whether we're members of the European Union or not. This House is not representative of the people. The executive is a legitimate branch of government. So can we be assured that in whatever workings there are increasingly with Parliament, that the executive will not give up its responsibilities, which are to implement the will of the people, which is a much greater body of sovereignty than this place?
Well, I think what is fair to say is that there is a range of views held in the House which are held sincerely by members of Parliament, but as I just alluded to, they cover a vast range of different deals. And I think the point of substance my honourable friend is referring to is the fact that the clear majority of the House did vote to give the public the decision on whether we stayed or left the European Union, and indeed the majority of the House then voted to trigger Article 50. And therefore it is incumbent on members of this House not simply to say what they are against, but also to be clear as to what they are for. But if I can make a little progress, and then I'll happily take some further interventions. For many, including on the benches opposite, the withdrawal agreement addresses many of the key issues that they themselves have spoken of. For example, Mr. Speaker, it protects citizens' rights. It protects the 3 million EU citizens in the UK and 1 million UK citizens in the EU. It also gives a financial settlement that honours our legal obligations. Not to do so, as members opposite have often pointed out, would undermine our international position. It guarantees an implementation period that means businesses have one change to make as we enter into a new trade deal, as opposed to two. But most importantly, Mr. Speaker, and this is an issue on which the benches opposite quite rightly should take great pride, because they played a key part in terms of the peace situation in Northern Ireland. It is a very proud record for the benches opposite, and the withdrawal agreement enables us to preserve that hard-won peace and ensure that the commitments that were made in the Belfast Agreement were honoured. I'll happily give way to the
Secretary of State realise that the withdrawal agreement, and especially the backstop arrangement, which actually forcibly would remove Northern Ireland from the rest of the United Kingdom, laws made in Brussels rather than Westminster, Northern Ireland economy cut off from trade deals which the United Kingdom would enter into with the rest of the world. That is has put in jeopardy the fine balance which there was in the Belfast Agreement, and it's not helped either by the reported comments of the Secretary of State to the Cabinet yesterday that a refusal to vote for this withdrawal agreement is likely to lead to a referendum on a United Ireland.
Well, firstly, can I say I very much recognise the very genuine concerns that the right honourable gentleman has in terms of the backstop. I will come on in my statement to address some of those, although I readily concede I don't expect to address all of them in terms of the areas of movement today. But I think also this is about assessing the balance of risk. The backstop doesn't cover the 80% of our economy, the services economy, that are actually outside. There's many within the business community of Northern Ireland that actually see huge benefits in terms of the certainty that is offered through the withdrawal agreement. And indeed, it isn't our intention to enter into the backstop for the reasons, not least, that many businesses in Northern Ireland will have access to both the EU and to the UK market, which is one of the attractions. It's actually one of the reasons why the sister party of the party opposite, both in the north of Ireland, the SDLP, and also in the south, the sister party of the party opposite, actually supports the withdrawal agreement, not least, as I was referring to, in terms of securing the implementations on peace. I'll, of course, give way.
I'm grateful to the State Secretary for giving way. The Scottish Government has made known for quite some time now a number of concerns it has with the agreement. So since December, when they cancelled the debate to go away and listen, what's changed in it that could make the Scottish Government now support it?
Well, again, I'm going to come on to that because I think as we move into the trade phase, the trade negotiation, the second phase of this, because this is a process, it's not a single event as we leave the European Union, it is a process. We're dealing with the winding down arrangements in this instance. We're then going to be looking at that. And I think there is a significant opportunity, I'll come on to this in my remarks, but recognising the fact that Scotland voted differently,